I don't have a bailiff to say, hear ye, but I think I'm empowered to convene this session by whatever authority someone has mistakenly vested in me. Good morning, and on behalf of my colleague, Professor Keith Whittington, and the Department of Politics, and the James Madison Program in American Ideals and Institutions, it is my pleasure to welcome you to our half-day symposium for the Sesquicentennial of the Slaughterhouse cases, one of the most important pivots in federal jurisprudence in American history. The Slaughterhouse cases earns a certain notoriety just from its name, which entices people to think that it must be something like the gunfight at the OK Corral. But in one way, Slaughterhouse is really much more pedestrian than that. If you put it in the simplest terms, Slaughterhouse cases really originated in a municipal reform bill in the New Orleans City Council in March of 1867, 2 years after the end of the American Civil War. And its general purpose was to regulate the dumping of animal waste from New Orleans butcher shops into the Mississippi River. It doesn't really get much more pedestrian than that. So it was, I suppose, an early example of environmental legislation, because the problem of disposing of waste from slaughtering cattle and sheep had plagued the low-lying city of New Orleans since the time of the Louisiana Purchase. What the city council proposed as a solution was the creation of a centralized, public-private Crescent City Slaughterhouse Company. But the butchers of New Orleans protested that this was forcing them into the service of a compulsory monopoly that had every evidence of becoming the corrupt money pump of New Orleans politicians. Wouldn't be the first time in New Orleans history. This could have been settled, I suppose, purely as a municipal matter. But the contest between the butchers and the city council was playing out against the larger background of Reconstruction in the former Confederacy. By the time the butchers filed their first lawsuit, Congress and the nation had passed and ratified the 14th Amendment, and the Butchers' Benevolent Association turned to the federal courts for relief, claiming that their federally guaranteed rights under that amendment, the privileges and immunities of citizens, the equal protection of the laws, life, liberty, and property as butchers, had been violated. In the summer of 1870, they appealed to Justice Joseph Bradley in his capacity as a circuit judge for the Fifth U.S. Circuit, and he granted them a writ of error on the grounds that the right to pursue their employment was protected as a right of federal citizenship. And that changed the face of the Slaughterhouse cases, since the 14th Amendment had been adopted with a view to protecting the civil rights of the freed slaves. Yet the actual language was broad enough to embrace any citizen. That new face to Slaughterhouse became more contorted when the Butchers' Associations hired as their lead counsel John A. Campbell, a former Associate Justice of the U.S. Supreme Court, who had defected to the Confederacy during the war. Campbell's argument before the Supreme Court gave matters an even stranger twist, since Campbell argued that the 14th Amendment had worked a radical change in the entire U.S. Constitution, making the federal government the only real governing authority in the country, and covering white workers and white businesses rather than just those of freed slaves. And so the question became, was Campbell hoping not just to help the butchers, but to disarm the intent of the 14th Amendment and thus subvert Reconstruction? The decision in Slaughterhouse cases was handed down on April 14th, 1873, ominously exactly 8 years after the assassination of Abraham Lincoln. It rebuffed Campbell's and the butchers' argument, and in so doing, the court decided that there were two distinct categories of citizenship, state and federal, and that the butchers had to be governed by the rules of their state citizenship, not by the federal citizenship described in the 14th Amendment. Since the privileges or immunities the 14th Amendment was being pled for by the butchers did not apply to them, This meant that the city council technically won this case, but it was not a happy decision. The majority opinion was written by Justice Samuel F. Miller, but dissenting opinions were filed by Justices Noah Swain, Stephen Field, and Joseph Bradley. And it would be a decision with long innings. Since voting rights were the constitutional territory of the states, any aggressive federal action on behalf of voting rights during Reconstruction could be hobbled. Beyond that, the effect of Slaughterhouse would continue to be felt through Cruikshank versus U.S. in 1875, Ex parte Yarborough in 1884, Allgaier versus Louisiana in 1897, Lochner versus New York in 1905, and even today. Slaughterhouse has generated important interpretive questions, such as, was the New Orleans City Council's action in creating that central slaughterhouse a reasonable exercise of police powers? Did Slaughterhouse deform the original intent of the 14th Amendment? Do the privileges or immunities of the 14th Amendment extend to economic and employment liberties, and perhaps other liberties? Would a reversal of Slaughterhouse, even after 150 years, lead to a revitalization of the original privileges and immunities clause? To lead us into this maze of interpretation, we welcome three very distinguished speakers. Pamela Brandwein, professor of political science and of law at the University of Michigan, and the author of Reconstructing Reconstruction, the Supreme Court and the Production of Historical Truth in 1999, and Rethinking the Judicial Settlement of Reconstruction in 2011. Her article, The Slaughterhouse Dissents and the Reconstruction of American Liberalism, has just been published by the American Political Science Review and will form the substance of her presentation this morning. Mark Graber is the Regents Professor at the University of Maryland's Carey School of Law and the author of A New Introduction to American Constitutionalism in 2013, Dred Scott and the Problem of Constitutional Evil in 2006, co-editor with our own Keith Whittington of American Constitutionalism, Structures and Powers. His most recent work is Punish Treason, Reward Loyalty, The Forgotten Goals of Constitutional Reform After the Civil War, just published this year by the University of Kansas Press. And he will speak this morning on the Slaughterhouse cases and the rise of the 14th Amendment, Section 1. Kurt Lash is the E. Claiborne Robbins Distinguished Professor of Law at the University of Richmond, and the author of The 14th Amendment and the Privileges or Immunities of American Citizenship in 2014, and the editor of the mammoth, and I do mean mammoth, 2-volume anthology of the Reconstruction Amendment's Essential Documents in 2021. His current project is A Troubled Birth of Freedom, the struggle to amend the Constitution in the aftermath of the Civil War. Each of our participants will speak for approximately 35 minutes, followed by a question time, which I will allow each speaker to moderate. And having spoken at entirely too much length already, I will cheerfully yield the floor to Professor Pamela Brandwein.
Good morning, everybody. And thank you very much to Alan and Keith for this really wonderful symposium this morning. I should apologize at the outset. I was sick last week, and I'm not quite running at 100%. And so I ask you just please bear with me. Hopefully I'll be able to get through this. So my focus today, as Alan mentioned, are the dissents of Field and Bradley, but not for the usual reasons. And there are two usual reasons for talking about the dissents. The first typical reason is to argue that they were right, that they recognized the alteration in federalism that was part of the Republican Party's anti-slavery reform agenda, that they recognized that the Republicans had made national citizenship matter, that Republicans had defined national citizenship to include basic substantive rights, property and contract rights, that had previously been elements of state citizenship only. And Bradley's dissent in particular is regarded as the fullest expression of the Republican reorganization of federalism, including the incorporation of the Bill of Rights and their application to the states. Now, the second usual reason for talking about the dissents has to do with Lochner versus New York. Now, the Lochner decision in 1905, of course, is famous for striking down New York's maximum hour law. And the orthodox view of that decision is that it was the result of laissez-faire policy preferences, that there was no institutional integrity to the notion of liberty of contract or substantive due process. And the orthodox scholars accuse Field or Bradley, or both of them, of being the father of all of this. They say that their dissents were the fountainhead of liberty of contract doctrine. Now, the Lochner revisionists exonerate Field and Bradley. And in political science, the most prominent exponent of this is Howard Gilman. And he argues, drawing on a whole body of historical work, that the dissents have institutional integrity, that they expressed a Jacksonian equal rights ethos that had already been institutionalized in the antebellum era in police powers jurisprudence at the state level, and that all that was going on in the post-war years was that this Jacksonian equal rights ethos was being nationalized. And this equal rights ethos, according to the revisionists, is exemplified by Richard Hofstadter, who talks about equal rights as just part of classic bourgeois liberalism. And so the two usual reasons for talking about the Slaughterhouse Dissents, one has to do with Reconstruction, the other one has to do with Lochner, and these are generally separate literatures. These accounts from the Lochner literature and the revisionist literature actually don't cohere. And that is the first thing I kind of want to call attention to, that the Reconstruction literature emphasizes that these dissents advanced substantive rights arguments, a substantive right to labor, absolute rights. Lochner revisionism argues that these dissents emphasized an equal rights ethos. Now, these stories don't cohere. And also, on top of that, there are these encrusted descriptions of the facts of Slaughterhouse that are shared in both literatures. One of these encrusted stories has to do with the supposed corruption of that 1869 grant. And that story of corruption kind of evokes one of these master narratives of Reconstruction, that the Republican Party had turned away from Black rights and toward big business. Now, there's a corrective from the historian Michael Ross, and it's beginning to seep into the judicial politics literature. And as Professor Gelzo mentioned, that there were absolutely abysmal health conditions in New Orleans. And if you read Michael Ross's descriptions, I mean, they're stomach churning. And I won't give those to you today because it wouldn't be good for me personally at the moment. But really just horrid descriptions of the filth and the cholera and the yellow fever that was coming from the fact that the butchers were dumping all this animal waste into the Mississippi River, which was the source of the city's water supply. And the butchers on top of this, and this is Ross's account, the butchers had been resisting reform for decades. And when the legislature, when the Louisiana legislature comes online, this is a Reconstruction legislature. It's a biracial legislature. And the butchers were hostile to the biracial legislature simply because it was a biracial legislature. And when this grant was passed, this grant that established a compulsory centralized abattoir, this had actually provided equal access to the butchers to Black butchers for the first time to get access to the trade. And then moving beyond Ross for a second, there's actually a literature that talks about the sanitation movement of the 1850s. European cities had been establishing these centralized compulsory abattoirs starting in the 1850s. Milwaukee had established one in 1866, again, a private-public combo. Chicago does the same thing. In the 1870s, Boston does this outside of Philadelphia. So what happened in New Orleans was actually part of a trend that had already been established and would only grow. And it was Democrats who generated this corruption story, and as Ross looked all around for it, and he really couldn't find any evidence of corruption at all. Now, another encrusted description, another encrusted fact, pertains to the butchers. And again, in both of these literatures, the Reconstruction and Lochner literatures, the butchers are portrayed as the little guys against the big, mean corporation. Charles McCurdy calls the butchers unemployed. Howard Gilman, drawing on McCurdy's work, calls them dispossessed. But the butchers didn't lose their work. They had to move their work. And again, this is consistent with what had been happening in big cities. And if you look at the title pages in the Slaughterhouse cases, you see the same names: Paul Esteban, William Fagan, and these members of the Butchers Association. Well, it turns out these guys were really well-heeled business owners. They were not sort of little guys. And in 1871, after they had lost at the state's highest court, and after they won before Bradley, these guys purchased the Crescent City Company. They became the quote-unquote monopoly that they had been raging against. Paul Esteban, William Fagan, they become the new board of directors of the Crescent City Company. And they brought a motion to dismiss, saying that there's no longer a controversy. And so it's all in the landmark briefs. It's been right in front of us all of these years, and yet the butchers still get narrated as these little guys. The court denied the motion to dismiss, and that's actually something to be thinking about in terms of, well, why did they deny that motion to dismiss? But what's clear is that Paul Esteban and William Fagan and the Butchers Association folks, these were actually quite wealthy men. And they did what happened in a lot of grants for public utilities in the United States. What would happen is that the legislature would give a grant to a private corporation, and then actual experts in the field would purchase that company because they had the knowledge to run it. And so what happened here was actually fairly typical. Okay, so I'm opening with this. You know, the usual reasons for talking about the Slaughterhouse Dissents, incohesion in the literatures, and these encrusted descriptions that really need to be revisited to really clear space for a new look at the dissents. And that's what I'm doing in this new APSR article that Professor Gelzo mentioned. And it's online, it's open access. Every single person here can access it. It's no paywall or anything like that. And the article basically makes two moves. The first move has to do with 19th century liberalism, which is long been regarded as classic liberalism. We don't get social welfare liberalism until the New Deal, but the 19th century, it's classic liberalism. That's the story. And the second move has to do with the Slaughterhouse Dissents. And what I actually offer in the article is really a new staged account of liberal development. And I present evidence that in the antebellum era, the public law liberty paradigm, the rights that citizens, and of course there's contestation over who's a citizen, but the public law liberty paradigm, the rights that citizens had against their states, the paradigm of liberal rights, is actually foreign to us today. It's not the classic liberalism paradigm. And that when you examine the conceptual architecture of the dissents, when you look at their conceptual structure, the way it turns out is that Field's main dissent is using the old architecture. He's using an old architecture that is actually foreign to us. And I'll obviously talk about that. And it's Bradley's dissent that's rearranging this whole old liberty paradigm. And it's in Bradley's dissent that we get modern private rights individualism. It's in Bradley's dissent that we get this construct of liberty as a purely private enterprise. And so let me sketch this. Let me sketch what I call a dual liberty paradigm from the antebellum era. Again, this is antebellum public law, the rights of citizens against their local and state governments. And in sketching this dual liberty paradigm, I should note that what I'm doing is I'm repositioning some of the work of the historian William Novak. So Novak had a book. He wrote this in 1996. It's called The People's Welfare. And what Novak does in The People's Welfare is that he identifies extensive regulation at the local and state levels. And he reprints pages and pages and pages of this, so you really get a sense of how extensive regulation really was. And it had to do with public space, the public economy, public health, public morality. And these laws were enforced. That's an important thing to mention. They were not just symbolic laws, they were enforced. And what Novak does is that he's tracing the legal political framework that legitimated this very broad, very robust and dynamic regulatory power, which was the police power. The police power is the regulatory power. And so the People's Welfare is really a study of the police power and its structure. Now, just as a note, Novak's study is after Gilman's. Novak writes in 96, Gilman was writing in 93. And so Novak's study comes after. And one of the things that Novak does is that he's identifying the key figures of the well-regulated society. The well-regulated society actually comes from Vanderbilt versus Adams. He takes it from a court case, but he uses this terminology. Novak talks about the antebellum era, the regime of the antebellum era, as the regime of the well-regulated society. And major figures are associated with it. The founder, James Wilson, New York Chancellor James Kent, he's a big guy, I'll be talking about him, Nathaniel Shipman, Zechariah Swift, big, well-known legal figures of the antebellum era. And Novak shows that these figures rejected key formulations from Blackstone, that they rejected Blackstone's formulation of absolute rights, that they rejected Blackstone's formulation of the public good. Now remember, Blackstone is writing in feudal England, where he's protecting the property rights of noblemen against the king. And these figures actually say, look, we are in an era of popular sovereignty. There is no king. We have legislatures popularly elected, and Blackstone's notions of natural law and his notions of absolute rights don't apply anymore. And so they develop this legal framework, this legal political framework, where they draw on a different stream of natural law. So are these natural law theorists? Yes, but they're using Scottish natural law, and they talk about the law of social nature. And so we have to be able to distinguish between these different streams of natural law thinking. And they develop this set of interrelated concepts, which Novak identifies. Big one, man as a social and relational being. Man is a social and relational being. Now, there were gendered and racialized versions of this, but when they're talking about white male citizens, they talk about men as social and relational beings, as not being atomistic in nature. Man is, quote, not made for independence and isolation, but made for mutual connection. There's also this idea that they articulated that liberty was a social enterprise, not just an individual enterprise. And they talked about liberty as being dependent in a robust way on legislation for the public good. This is not a night watchman state model, that they were aware that they were in a burgeoning society that was rapidly changing, and that they viewed legislatures as having the duty to protect and improve social life. So the object of government, the role of government, was to protect and improve social life. And importantly, they conceived of rights as relational in nature. And this is totally foreign to us, that property rights are relational in nature. There's this construct of social and conventional property rights, that property rights were seen as deriving directly or indirectly from government, and therefore subject to regulation for the common good. Now, there was a limit on regulatory power. Power was not unbounded. And that limit in law was a construct called common rights, or the rights of the community, or public rights. These were all synonyms in the police powers idiom. And partial legislation, legislation for a faction, legislation for a few, was recognized as invalid and unequal. But it was recognized as unequal. The harm of partial legislation was that it violated common rights. It violated the rights of the community. And the logic here is key. The logic is that partial legislation was not general legislation. And they used a distinction between partial and general legislation. But partial legislation was invalid because it violated liberty, which was conceived as a social enterprise. Okay, partial legislation is invalid because it violates liberty as a social enterprise pursued by social and relational beings. Now, this is a concept of unequal law that is foreign today. It's absolutely foreign. There's the language equal rights, but it can get confusing because we still have that terminology today. But their conception of unequal was tied to a conception of liberty as a social enterprise pursued by social and relational beings. This is actually the construct of equal rights that you see in Field's dissent, and I will get to that in a bit. But what Novak shows, kind of bottom line, is that this was not the world of atomistic individualism. This was not the world of atomistic rights. But Novak himself actually runs into trouble on something. And I identified this in the piece. And Novak himself runs into trouble because there is, in fact, a notion of absolute rights that circulates in the antebellum era. And in his 1996 study, Novak says, well, rights were never absolute. Civil liberties were never absolute. But then in a follow-up study last year, he calls absolute rights rare. And, well, there's a big difference between zero and rare. And he never goes back to reconcile this. We never get an account from him about, well, what's rare and how does that work with your prior study? And in fact, Kent, one of his major figures of the well-regulated society, uses the notion of absolute rights. So Novak gives us no way of understanding Kent on absolute rights. So part of what's new in the APSR piece is that I take Kent seriously. It's like, well, what does Kent mean by absolute rights? And when we do that, we get what I'm calling the dual liberty paradigm. And to briefly state it, this dual scheme goes like this. If you look at Kent's commentaries, what he says is that the rights of free men vis-a-vis government. Now remember, they're already free. He's not talking about slaves. He's not talking about slavery. He's talking about the rights of free men versus their government arise from civil relations and from what he calls a single unconnected state. So rights arise from these two different conditions: people in civil society and people in a single unconnected state. And the rights arising in civil relations are social and conventional rights, are social and conventional property. Common rights arise from civil relations. And so you should be thinking, oh, police power. But rights arising in a single unconnected condition, Kent calls these absolute rights. Now, he says there is a minimalist absolute rights framework. And I recover this. And if you look in his commentaries, and even if you look in his index, there are 4 and only 4 entries on absolute rights. And having a search function really helps these days, I can tell you that much. And what Kent says is that these rights arising in a single and unconnected condition, he says he confined the manual to a few unexceptional principles. So he's basically giving us our own manual of these absolute rights. And these rights, if you look at his pages, they are in state constitutions. He emphasizes the writtenness of them, and he calls these rights, and only these rights, the rights of Englishmen. So what are these rights? The first one is personal security. And here he identifies a very small group of penal protections. Things like no double jeopardy, the necessity of charges, bars on bills of attainder, a bar on ex post facto laws, and he identifies due process in a procedural sense. as requiring a regular course of administration. That's it for personal security. Then there's also the absolute right of personal liberty. But how he defines this is habeas corpus only. That's it. Personal liberty is an absolute right, but it's habeas corpus only. There's also personal liberty, by which he means free expression. And then he also identifies the right to, quote, acquire and enjoy property. And he doesn't explain this in his manual. He says, I'm going to talk about this elsewhere. So again, that search function is very helpful. And when you search for absolute property or absolute anything regarding property, what you find is a couple of things. He talks about absolute title. And he cites Fletcher versus Peck. And he makes very clear that what absolute title means is that ownership vests. Ownership vests. And by power over title, what he means is dominion, his term. And dominion simply means selling or bequeathing. It means control over that title. What you do with that property is dominion. That's what he means by enjoying property. It's dominion over it, making decisions about what to do with it. He also identifies fair compensation for takings. And he had done this years ago in Garner versus Newberg, where you have to have fair compensation for takings. And so the use of property, again, not ownership, but use, that is a social and conventional right for Kent. It's social and conventional. It's not absolute. And so the use of property, that's a right that arises in civil relations and is subject to the police power. And so what you get when you look at Kent is property rights as dual. As property rights arise in civil relations, the use of property, it's social and conventional and subject to the police power. As it arises in a single condition, that's absolute title. That's just compensation for takings. And so just to pause, so we have this dual liberty scheme. As a general matter, scholars of American governance have basically missed this dual liberty paradigm. The common way it gets missed starts with Corwin. And what happens is that rights arising in a single or unconnected condition are mistaken as the whole, and liberalism gets narrated as atomistic liberty across the whole 19th century. And if you look at Corwin's cases, the actual cases he's citing all refer to rights that are actually in Kent's manual of minimalist rights. It converges. It's so neat and clean. Now, Novak misses the dual liberty paradigm from the other direction. He takes rights arising from civil relations. He takes social and conventional property as the whole. And according to Novak, we don't have American liberalism starting until after the Civil War. And so in the APSR piece, I'm identifying this dual liberty paradigm as a form of liberalism, because it is a form of liberalism. And I'm reading the Slaughterhouse cases against it. And what we find is, again, is that Field is maintaining it. He's maintaining the conventional police powers framework, but Bradley is totally rearranging it. So now let me just turn to this. So Field's main dissent, and it's joined by Chief Justice Chase. Chase had gotten ill for a little while, but he's back on the court. And I think it's significant that he joins Field's main dissent and not Bradley's. So what Field says repeatedly in his dissent is that exclusive grant violated common rights. He says this repeatedly. He says that issue is, quote, nothing less than the question of whether the recent amendments protect citizens of the United States against the deprivation of their common rights. He uses unequal and against common rights as synonyms. And this is the standard synonym in the police powers framework. He invokes the English monopolies cases. He invokes Corfield versus Coriel. He invokes Adam Smith, all in the service of saying that exclusive grant violated common rights. Now, contrary to Lochner orthodoxy, this is not a substantive rights argument. It's a common rights argument, and that common rights argument has to be understood in the ways that I just indicated. And contrary to Lochner revisionism, this is not Hofstadter's equal rights classic liberalism formulation. The common rights formulation is tied to that whole legal political structure of the dual liberty paradigm. Now, what Field is really doing here is that he's extending the police powers framework of the well-regulated society. That's what he's doing. He's resourcing in national citizenship common rights that already belonged to state citizens, already established in the antebellum era. Now let me turn to Bradley's dissent. Now, if you remember in police powers jurisprudence, partial legislation was invalid, and it was invalid because it harmed common rights. It harmed these social and conventional rights. What Bradley's dissent did was that it redefined the harm of partial legislation. For harm to common rights, Bradley substitutes harm to pre-social absolute rights. And with that, he's redefining liberty as a purely private enterprise. Remember, under the dual liberty paradigm, liberty is a social enterprise as rights arise in civil relations. You only have these rights in a single unconnected condition, so those things combined. But what Bradley's doing is that dual liberty paradigm goes away and liberty emerges as a purely private enterprise. He's keeping the distinction between partial legislation and general legislation. That distinction was part of police powers jurisprudence. Bradley maintains it, but he's redefining the harm of partial legislation. Another way of saying this is that he's rearranging the paradigm of liberal rights. And he's doing that by reorganizing police powers jurisprudence. Now, how did he do this? Well, he misstates police powers jurisprudence. He gives a false description of what police powers jurisprudence did and how it did it. He said that the absolute right to labor, a substantive right, was what made mere monopolies void at common law. That's false. It was common rights that made mere monopolies void at common law. And more broadly, what Bradley is doing is that he's presenting a story of the unbroken lineage from Blackstone to the 14th Amendment regarding free men's absolute rights. The only thing that changes, according to Bradley, is then you get new federal protections for these absolute rights. But he's saying there's this unbroken lineage from Blackstone to the 14th Amendment with regard to the existence of these absolute rights. And this is also false. Kent and the legal figures of the well-regulated society rejected Blackstone's formulations of absolute rights. And we see this in that dual liberty paradigm, which was distinctively American. So this common law formulation that these figures of the well-regulated society articulated used English common law axioms, salus populi, the people's welfare is supreme, but they are redefined, and there is a distinctive American interpretation of them, which was institutionalized in police powers jurisprudence. Now, I go into more detail on this in the APSR article, but just briefly, the way Bradley did this, the way he constructed this story of unbroken lineage, involved two grafts. And I take the metaphor of a graft from medicine, which is where there's a transplant. And Bradley basically grafted into police powers jurisprudence. He grafted into the antebellum legal landscape Blackstone's pre-social absolute rights scheme. And that scheme is where you have atomistic individualism. It's where liberty is a private pursuit. It's where property is a pre-social right. So Bradley is taking that Blackstone scheme on absolute rights and he's grafting it into the American story. Now he's also grafting in language about the rights of Englishmen from Kent. Now Kent, if you remember, used that phraseology, the rights of Englishmen, only as it pertained to those minimalist absolute rights that arose from a single condition. Minimal penal protections, habeas corpus, free exercise, title, fair compensation. Kent called those rights the rights of Englishmen, but he was not using the phrase rights of Englishmen to describe rights arising in civil relations. It was only those rights that arose from a single unconnected condition. So what Bradley's doing is he's taking that right, that phrase, the rights of Englishmen, and grafting it onto police powers jurisprudence, which is a thing. This is creative, conceptual work that he's doing. And by creative, I mean conceptual, it's new. He's rearranging the police powers framework via these grafts. But the key point is that the rights of Englishmen formulation does not apply in Kent's formulation to social and conventional rights, which are the rights that are regulated by police powers. But Bradley attaches the rights of Englishmen to the rights regulated under police powers. And so in Bradley's dissent, this dual liberty scheme is rearranged. Another way of saying it is that he takes an axe to it. It's collapsed. It's collapsed into a single scheme where you now have pre-social absolute rights. And I mean, to put this differently, Bradley is basically substituting Blackstone for Kent. And part of the problem is that American scholars haven't generally recognized that Kent's framework is in fact foreign. Kent's framework has been assimilated to Blackstone, and that's been a mistake. And so we have to be able to actually distinguish these frameworks to be able to see that Bradley is substituting Blackstone for Kent. And so in Bradley, we get a personal liberty right to choose one's calling, replacing Kent's personal liberty, which again for Kent meant habeas corpus, and that's it. And so to sum this up for Bradley, what Bradley said was that there was an unbroken lineage of absolute rights from Blackstone to the 14th Amendment. And the only thing that gets changed on property and contract is that the federal government now has capacity to enforce it. Scholars have thought this story is correct because they're unaware of that dual liberty paradigm. Now, what Bradley did versus what he said, what he did is that he redefined the harm of partial legislation. He reorganized police powers jurisprudence. He's reconstructing the legal subject in purely individualist terms. He's redefining liberty as a purely private enterprise. And it's also worth noting in this respect that equality, equal rights, gets redefined. In the well-regulated society, equal laws meant common rights. Pursued, liberty is a social enterprise, pursued by these social and relational beings. In Bradley's new framework, equal rights now is defined in relation to private pre-social rights. So equal rights is actually getting redefined as a concept in American law. And so I'm arguing that his dissent is really about the eclipse of the dual liberty paradigm. And it's in his dissent that we get modern rights individualism. And this framework, Bradley's new liberal rights paradigm, diffuses fast. It gets institutionalized fast, which suggests that multiple groups found it useful. It suggests that multiple groups found it useful for different purposes. Now, of course, Slaughterhouse involves the Privileges or Immunities Clause. But what Bradley did in his dissent is that he tied this story of unbroken lineage to all the clauses in Section 1. And he ties it explicitly to the Due Process Clause. And what we get in Munn versus Illinois in 1877, just a few short years later, all of the justices, majority and dissent, all of them, use Bradley's reorganized police powers jurisprudence. All of them use the new definition of the harm of partial legislation. It's now harm to purely private rights. All of the justices they just move without saying they're moving. The harm of partial legislation is now to purely private rights for all of the justices going forward. Now, I want to wind down, I want to close by just saying something about the proximal roots of all of this. The proximal roots of this new liberty paradigm is liberty is a purely private enterprise. On this question of proximal roots, I've been asked, well, wasn't it John Campbell who did this? Wasn't it John Campbell who did this whole big rearrangement and Bradley just copied him? I've also been asked, wasn't it Thomas Cooley? It was really Cooley who did this, right? Cooley wrote in 1868. I've also been asked, well, wasn't it really Herbert Spencer? He wrote in 1851. He was doing this, and Bradley just sort of took what they were doing and put it into con law. And I show in the article that it wasn't any of them. But this question of proximal roots is a huge question. It's an enormous question, and I give no definitive answers. It's parts of a new project that I'm working on. But it makes sense to ask, well, how might the anti-slavery movement be implicated here? What I do is I caution against a simple equivalence between anti-slavery and atomistic individualism. I think we have to be very cautious between assuming those things are coterminous. Frederick Douglass in 1851, speaking on the need for civil government, he used the formulations of the well-regulated society. He's using those idioms. He talks about man as a social being as well as an individual being. And there are other examples along these lines. Now, available certainly in the antebellum era was a demand for self-ownership as a new absolute right in an unconnected condition. Absolutely. New absolute right in an unconnected condition that otherwise left the dual liberty paradigm intact. Equality claims could arguably be handled under the old liberty paradigm because that was all about making distinctions among groups of people. And of course, the citizenship rights claims of free blacks. These were equal rights claims. But we don't really, I think we need to go back. We need to go back and look at these discourses. Some Republicans in the Reconstruction Congress talked about absolute property and contract rights. But I used to read I read these debates 20 years ago, and I think scholars continue to read these debates as assuming that an atomistic, classically liberal rights scheme already existed. Now I don't think that's the case. I think there's plenty of evidence that that actually wasn't the case. And so I think we need to be asking how that dual liberty scheme functioned politically, who was attacking it, for what purposes, how critics picked up adherents. It's clear that the police power was a potent regulatory tool, and we should really be investigating an interaction between the anti-slavery movement and capitalist development. But the upshot here is that liberty as a purely private enterprise was a post-Civil War innovation. It was modified during the New Deal. Private rights got resourced from natural law to positive law. But this familiar legal subject that we have today, it really appears only with the court's encounter with the well-regulated society. And that's what the Slaughterhouse cases was about. Bottom line here, the Slaughterhouse cases was really the court's first encounter with the legal structures of the well-regulated society. Thank you very much.
Let me open the floor here for questions for Professor Brandwein. And what I will ask is that you direct questions to her. I'll allow her to indicate the time to speak, the moment to speak. The general practice that we try to adopt here is to invite student questions first. So I think if there are student hands that want to go up, maybe we'll give them priority at this moment. And then we'll let Professor Brandwein move ahead with other questions as they are indicated by people raising their hand. When you rise to speak, by the way, please identify yourself. Just say who you are.
I'm not a student, though. So.
Oh, we're all still students.
I know. I knew someone was going to say that. Wonderful. This is making me think so many different things. What a beautiful conceptual revisiting of Slaughterhouse. Maybe just some quick questions and some that I know that you're continuing to think about. The majority opinion by Justice Miller. Do we have a third approach from the dual liberty paradigm, absolute liberty paradigm? What is Miller's approach? That's worth investigating. If you had initial thoughts about that, I'd love to hear those. Then, in terms of the anti-slavery movement, a couple of things are happening, and this would be more in my wheelhouse, and I'll talk a little bit about this later on. Yes,
well, it's a preview for your remarks coming up.
Everything is downhill from here, but yeah, it's going to be affected by yours. You have, as part of the anti-slavery movement, and even beyond the anti-slavery movement, reconceptualizing ideas of rights, of course, are occurring between the founding and the Civil War. Ideas of equal citizenship, major part. You're right. So where do absolute rights come in? When is this new idea of atomistic individual rights? Perhaps that's going to take you into the exchanges and debates over the absolute rights in the Bill of Rights, reconceptualizing our understanding of the Bill of Rights as not federalism rights or collective rights, but new thinking about those rights as atomistic rights through the engagement with slavery and freedom of expression and assembly and things along those lines. That's where I would begin to think about it. But you have opened the door to my thinking on all of those things due to your theory. I think it's wonderful. So if you want to respond, great. I'd love to hear.
Two brief thoughts.
Okay.
But I can absolutely keep it brief. On the reconceptualization of rights, let me say two things. The first one is that I'm not sure that when it came to Black abolitionism and all of Martha Jones's evidence and birthright citizenship, for example, the claims for equal rights, I am not sure that there was any reconceptualization of rights going on there except for the claim for absolute self-ownership, which was part of that reform agenda. And that would be a claim to expand those minimalist absolute rights for rights arising in a single unconnected condition. I think there's absolutely an argument for the expansion of the single unconnected rights to include self-ownership. But I'm not convinced, and again, I have to go back and look at this stuff because I'm now looking at it with fresh eyes. I'm not convinced that there's any reformulation of that dual liberty paradigm coming specifically from Black abolitionists. Now, on the free expression question, I think one of the things that comes out of, there's a new article out by Judd Campbell, who's writing on the First Amendment, and what Judd shows is that free expression rights were conceptualized as governed by the common good. Now, Judd doesn't make this move, but I think I can make it now, which is that once you formulate rights as governed by the common good, these are social and conventional rights. They're not absolute rights. Again, that distinction is absolutely crucial. And when you conceptualize free expression rights as common good rights, as social and conventional rights, if there's an argument that, well, these should now be conceptualized as absolute rights, it's clear to me that they weren't ever conceived as absolute rights. They were social and conventional rights. So I think there's a move, there's a scholarly move to be made somewhere to say that, at least with regard to free expression rights, they're getting reformulated. Now, jury trial rights, under Kent's formulation, seem to be an absolute right. But he's a little wishy-washy on that. He does not include that in his manual. That's not included. But free expression rights are clearly not included in there. And free expression rights are the big one, for the incorporation argument. It's always about free expression. And so there definitely seems to be possibly a conceptualization of free expression rights. But I think what we can do now is to say, well, before the Civil War, they clearly were not conceived as absolute rights. They were social and conventional rights governed under the police powers framework. So stuff is going on there with reformulation. And then just briefly on Miller, rereading his opinion now that we sort of have the idiom of police powers, which I think we have now, you can see in his majority opinion this conceptual discordance. He uses the police powers formulation of, well, is the 1869 law in violation of the rights of the community, or is it in violation of fundamental rights? And that's conceptually discordant because in the police powers idiom, that idiom didn't include fundamental rights. It didn't include absolute rights. And Miller says, well, you know, we have to decide if that 1869 law is in violation of public rights or private absolute rights. And he's gesturing to each of the dissents here because it's Field who's saying it's in violation of public rights. It's Bradley who's saying it's in violation of private absolute rights. But these formulations are fundamentally discordant. They're discordant, and it's clear there's conceptual churn happening. And Miller is caught. I mean, his majority opinion conceptually, Kurt, and this is all I'll say because you're going to talk about this more in detail, but I think it's conceptually fraught because there's no consistent framework there, because I think he's feeling the pressure of Bradley's dissent, because Bradley's dissent resonates, at least with the discourses of the Reconstruction Congresses. But now it's fundamentally unclear to me, and I think we all have to go back and relook at these debates, having clearly that dual liberty paradigm in mind. I'm not sure how many of these Republican framers were aware of this. Some of them might have used the phrase absolute rights just to mean, well, absolute equality. Now, it's a contradiction in terms, but there's some evidence that that's actually what some of them just meant. Oh, yes, sir.
So I was wondering, what degree do communities have absolute rights in the old theory, in that, as you're talking about, like with Judd Campbell's work on free expression, it's something that's limited by society and by convention. But from my understanding, specifically regarding class legislation or partial legislation, like in the work of Stuart Banner, it's seen as like any kind of law like that is violating the natural law. So that would seem to be something that's absolute, even if it's ultimately violating community liberty, not individual liberty. So to what degree under the old theory do communities have absolute rights?
So here's the thing. It was seen as a violation of natural law, but you have to understand that that Chancellor Kent and Zechariah Swift and Nathaniel Chipman, they're using a different stream of natural law. And they're going to say that under natural law, the community have these social and conventional rights. And so for the rights that are governed by the police power, it's never absolute. It's never absolute. And if a law gets struck down because it violates ex post facto, that's an ex post facto law. That's not a police powers law. So an ex post facto law is going to get struck down because it violates an absolute right. And that absolute right is you can't be subject to an ex post facto law. But the key thing is that ex post facto law is not partial legislation. It's ex post facto legislation. And so under this dual liberty paradigm, the rights of the community, the common rights, are always social and conventional. They're never absolute. Absolute rights can be violated by legislation, absolutely. I should be careful with that. Absolute rights can be violated by legislation, but that legislation is not treated by courts as police powers legislation. It's ex post facto legislation, or it's legislation that violates a jury trial right. Does that help?
Yeah.
Hello, I'm Zach. I'm a sophomore planning to study politics. I had one question about, under kind of your conception of the dual liberty paradigm, and I'm thinking about rights that seem to be at least that touch deeply on the individual, but also very much on the community. And that is freedom of conscience or liberty of conscience. And then as an expression of that, the liberty of free exercise of religion. And how does that fall into?
Those are separated. Those are separated. Kent absolutely separates them. He separates freedom, free exercise, which he conceives as a religious right, from political expression. Those are absolutely separated for him. And the religious exercise, he does conceptualize as an absolute right. But if you're talking about censorship in the mails because of anti-slavery, if you're saying anything about the whole slavery conflict, that's free expression. And that's treated as a social and conventional right.
So in that instance, then, if there were, under the use of police power in a state, kind of under this conception, how would any foray into the rights of a certain religious community to exercise their religion? I'm thinking, I've been doing a little bit of kind of research into, and this falls more into issues of treason during the Civil War, but certain religious communities in the South that were overtaken by Union soldiers, and certain pastors replaced, or certain communities kind of separated because of advocacy for slavery or anything of the like. But what kind of, and that's obviously more of a federal issue because it's the federal army. But if you take that more as a state issue and states somehow pass some certain legislation targeting a specific religious.
What year are we? Because the closer we get to the Civil War.
That's probably not a good example because that was during the Civil War. But let's say then within the states during in the antebellum era, let's say, if there was a piece of legislation targeting a specific religious community, how would that fall under the paradigm of dual liberty?
My guess, based on what Campbell is saying and what I'm remembering from Kent, is that if that religious community was writing to the newspaper and advocating a position, it's going to be treated as expression, and it's going to be regulated. And there's tremendous regulation of expression under the police powers. And it was seen as well, this is about the community health, so we're about, and again, obviously this is ideological, of course. It's political all the way down. But it's going to be upheld. Don't forget, we're in southern states and southern courts. But if you're in the North, and you're having a meeting of friends, and they're having some anti-slavery kind of something or other, first of all, it's not going to be legislated against. So you're not going to run into that situation. Do you know what I mean? And so the distinction, it seems to be for Kent, is that you have the right to practice your religion, and he's understanding religion in narrow terms. Once you go into taking a position on the slavery conflict, it's no longer religion, it's expression. And of course, you can argue about that, right? That's a distinction that gets made in politics. And we have to understand that distinction is made in politics. But how it would happen in law, given the way the police powers functioned, is that it would be treated as expression.
In my usual maniacal determination to observe the clock, I will ask you now to thank Professor Brandwein for that remarkable presentation. And we will turn next to Professor Mark Graber.
It is a great honor, and I thank Alan and Keith for inviting this American Jew to talk about the rights of African Americans on Rosh Hashanah. My rabbi wouldn't let me give the sermon, so here I am. Now, it's appropriate that I say to talk about the rights of African Americans because most of us learned about the Slaughterhouse cases at a time where the New Deal conceptual universe was hegemonic. And nobody in the New Deal thought the Slaughterhouse cases were worth studying for what they said about the butchers. That was obvious. Miller was right, And if he had only just thought he was not being paid by the word, put a period after the discussion of the police power, wrote the end, it would have been a perfectly good opinion. The issue is, what did he say about the 14th Amendment afterwards, and how did that affect the rights of African Americans? And the traditional question we ask of Slaughterhouse is, was the interpretation of the 14th Amendment, specifically with respect to the rights of African Americans, was that correct? Everybody is interested in the question. The challenge, and I'll add Professor Brandwein is clearly up to that challenge, as is Professor Lash, is could you say anything new that hadn't been said? I want to ask a very different question, and in many ways it's highlighted by Alan's introduction, where he simply said, well, the 14th Amendment's about Section 1, and this is the crucial thing interpreting Section 1. The thesis I want to advance today is that Slaughterhouse is a very important part of the process that makes us all reduce the post-Civil War amendments to Section 1 of the 14th Amendment. The good news is, I think this is an entirely new thesis, or at least it was an entirely new thesis when I started arguing it about 7 to 10 years ago. The real question is, well, given no one else has been saying this for 150 years, isn't this just wacky? And what I hope to do is persuade you I'm not entirely wacky. What I want to do is start off with a very familiar set of quotes from Slaughterhouse, which describe the history of the Reconstruction amendments, suggest that history is wrong with respect to Section 1 in the 1860s, and briefly review some events in the 1870s, including Slaughterhouse, that led us to think that history is right. So we start. Slavery was the cause of the Civil War. Miller writes, the institution of African slavery, as it existed in about half the states of the Union, and the contest pervading the public mind for many years between those who desired its curtailment and ultimate extinction, and those who desired additional safeguards for its security and perpetuation, culminated in the effort on the part of most of the states in which slavery existed to separate from the federal government and to resist its authority. This constituted the War of the Rebellion, and whatever ancillary causes may have contributed to bring about the war, undoubtedly the overshadowing and efficient cause was African slavery. Now, the good news is here we have in 1873 a decisive refutation of the lost cause, of the literature that said slavery had no role whatsoever in the 14th Amendment, that in fact it was simply about state rights, about the right to secession. But in some ways, Miller goes to the other extreme. So we might imagine a coup or a secession movement that's simply based on the fact that the secessionists want to take over, or the coup want to take over the government because there's more money when you run the government than when you don't. Now, in one sense, we might say the coup was about money, though first we wouldn't abolish money because people wanted money, but we'd also say the coup was about disloyalty, that people seceded because they had theories about the Union, theories about loyalty that permitted them to secede, that if we should not read slavery out of the causes of the Civil War, we shouldn't read state rights out of them either. If there was no doctrines of state rights, no theories of national power, people would not know how to articulate the grounds for slavery. Well, the second premise, the abolition of slavery, was a consequence of the Northern victory in the Civil War. So we have in that struggle slavery as a legalized social relations perished. And this, of course, is right. And by the way, another wonderful thing about this section, which I have skipped reading all of it, is that Miller gives a nod to the role of African American troops in the Civil War. But notice, even here, what we have is simply a version of the 1866 democratic vision, something Professor Brandwein pointed out in an earlier book. That is, Miller is beginning to say it's the Constitution as it was. The democratic cry in 1865 minus slavery. Nothing else really changed except for slavery. And then Miller narrowly defines slavery. The 13th Amendment abolishes only the right of one person to own another person and analogous practices. That a personal servitude was meant is proved by the use of the word involuntary, which can only apply to human beings. The exception of servitude as a punishment for crime gives us an idea of the class of servitude that is meant. The word servitude is of larger meaning than slavery, as the latter is popularly understood in this country, and the obvious purpose was to forbid all shades and conditions of African slavery. It was very well understood that in the form of apprenticeship for long terms, as it had been practiced in the West India Islands, on the abolition of slavery by the English government, or by reducing the slaves to conditions of serfs attached to the plantation, the purpose of the article might have been evaded if only the word slavery had been used. And that is all we deem necessary to say on the application of that article to the statute of Louisiana now under consideration. Notice, in the Slaughterhouse opinion, we never talk about the Civil Rights Act of 1866, the Freedmen Bureau Bill, the Second Freedmen Bureau Bill, bills that took a different view of slavery immediately after the passage of the Civil War. These are removed from the consciousness of the 13th Amendment. The Black Codes, Miller then says, spurred the need for additional constitutional amendment. And then there is a long list of the problem of the Black Codes and the Republican problem to them. What is missing? Well, it turns out Republicans had other complaints about what was going on in the antebellum South. Complaints, once again, Miller removed from history. First, there was the problem of white Republicans. White Republicans did not have it as bad as African Americans, but that's only by saying being tarred and feathered and sent out of town is not as bad as being whipped and murdered. White Republicans were fearful for their existence, fearful for their property, fearful for their rights throughout the ex-Confederate South. Republicans are talking about fears of renewed secession or renewed war They've lost temporarily, but they're just looking for another opportunity to come back. You hear those fears throughout the 39th Congress. You do not hear those fears in the Slaughterhouse case. You hear fears that what new Southern governments are going to do is first, repay the Confederate debt. Second, compensate slaveholders for their slaves and tax white Republicans to pay that. This is stated as often as complaints about the black codes. Miller erases it. And finally, you hear fears that one of the things that Southerners are going to do when they return to power is they're going to repudiate the national debt. And by the way, if you are a poor Union widow, and appeals to widows and orphans in 1865 are as same as appeals to widows and orphans anywhere, our widows and orphans aren't going to get their promised money. All of this is read out of history by Miller. Finally, the 14th Amendment is framed in response to the black codes. That Section 1, and maybe Section 5, though not really, is the only provision of the 14th Amendment. There's some extra words there because the framers were paid by the words, but don't look at them. They don't matter. Miller says, these circumstances, whatever of falsehood or misconception may have been mingled with their presentation, forced upon the statesmen who had conducted the federal government in safety through the crisis of the rebellion, and who supposed that by the 13th article of amendment they had secured the result of their labors, the conviction that something more was necessary in the way of constitutional protection to the unfortunate race who had suffered so much. They accordingly passed through Congress the proposition for the 14th Amendment, and they declined to treat as restored to their full participation in the government of the Union the states which had been in insurrection until they ratified that article by a formal vote of their legislative bodies. Sections 2, 3, 4 do not exist. 13th Amendment, only about slavery. Now, there are two things I want to say about this. The first is a relatively easy dive that I'm going to spare you, because I find the good news for me is when I talk about this, people are pretty convinced, and I would like to thank Donald Trump personally. I'll add, as you know, most professors were progressives, and even those who are not progressives don't tend to like publicly Donald Trump. We get so much media, we get so many interesting problems. I don't know what we would do without Donald Trump. But after Donald Trump, nobody says the other provisions of the 14th Amendment, who cares about them? And it's become very easy to convince people that yes, sections 2, 3, and 4 are not in the 14th Amendment because the framers were being paid by the word, or somebody said a 5-provision amendment is lucky. Let's just throw 3 random provisions in that nobody cares about. That in fact, they really mattered. That what Republicans were trying to do was not protect rights by saying, here's a legal right, we certainly hope you obey it, but restructuring the United States government so only loyal people committed to the Union war aims in the Civil War would govern, and the assumption was if the loyal governed, rights would be protected. And by the way, if the loyal didn't govern, rights would not be protected, no matter what the Constitution said. But I want to try to argue something far more controversial on something I've had no luck persuading anyone. But you're a relatively big audience, there are about 30 people here, let's go for 1 or 2. And that is that Section 1 did not matter. That the section Slaughterhouse put at the heart of the 14th Amendment was over here on the periphery. And the conventional view is that, yeah, people passed Civil Rights Act of 1866, but a good many of them thought it was unconstitutional. You needed legislation. There are a number of problems with that view. We start with the Second Freedmen Bureau Bill. Nobody who voted for the 14th Amendment expressed doubts about the constitutionality of that bill. They expressed no doubts, even though the bill did not simply cover former Confederate states, but in fact the Second Freedmen Bureau operated in slave states such as Kentucky, Maryland, which had stayed with the Union. They expressed no doubt, even though the Second Freedmen Bureau Bill operated in portions of states such as Southern Illinois that had stayed with the Union and never had slavery. They expressed no doubt, even though the Second Freedmen Bureau Bill protected approximately the same rights as the Civil Rights Act of 1866, and in some ways may have been slightly more expansive. They expressed no doubts, even though the bill provided goods and services for freedmen and refugees, and in practice, free persons of color. They expressed no doubt, even though many, though not all, regarded the Freedmen Bureau Bill as race-conscious legislation aimed primarily at African Americans. Even John Bingham claimed the Second Freedmen Bureau Bill was model legislation. Now, here it's interesting because Bingham also says, but it was confined to the ex-Confederate states, and that's simply false, and he knew it. What do you make of this? I don't know. Civil Rights Act. For some reasons, actually, Professor Lash has pointed out, has similar problems. Now, we know Bingham objected to the constitutionality, and Bingham objected to the constitutionality on a number of grounds. One was Section 1, which is the right section, which I'll get to. The other was Section 2, which is the remedy section. It's important that he also had that objection. We'll see for later on. He objected to the language, there shall be no discrimination in civil rights or immunities among the citizens of the United States or any state or territory of the United States on account of race, color, or previous condition of slavery. And in fact, approximately 35 Republicans joined Bingham, joined by other Democrats, in recommitting the Civil Rights Act. The Republicans who didn't say, what do you mean? These words don't mean what you think they mean. Bingham says they grant the right to vote. The other Democrats, no, they don't. Bingham said these are, in some sense, absolute rights. No, they don't. They don't give the state the right to make contract law in the state. They simply say equality. Bingham said, no, you're wrong. But whatever. Republicans decided better switch than fight. The new version of Section 1 was the version Bingham proposed. Now, Bingham actually said it's better than nothing. There's still problems with it. But what is interesting is every Republican, with one possible exception, Charles Phelps, who had supported Bingham in the motion to recommit, now approved the Civil Rights Bill. So rather than Republicans have doubts, Bingham had doubts. There may be one other, Christopher Columbus DeLong. No, Kurt and I will probably have a fight about that, and since I don't precisely remember why I think you're wrong about Delano, we can't even have that fight. Yeah, but it's not a huge number to the point. The last major speech given on the floor of the Civil Rights Bill is by a man named Lawrence, and he says, we had a fight over the meaning of the language. We changed the language. We're all happy. Now, again, maybe he's not speaking for everyone, but he's probably speaking for a lot of ones. And what's really interesting is there are 50 Republicans who propose omnibus 14th Amendment and reform packages. Before the Civil Rights Act, some say we need a constitutional amendment, some say we just simply need legislation. After the Civil Rights Act is repassed over Johnson's veto, those provisions get left out of proposed 14th Amendments to the point where Henry Wilson, a Senate radical, is describing the 14th Amendment, he forgets or he omits talking about Section 1. Doesn't even exist. So what happens? Well, in the 1860s, it's the 13th Amendment. The 1870s changes things. The first change is the Civil Rights Act of 1871, which is originally based in part on the 14th Amendment. But when Samuel Schellenberg of Ohio introduces the measure, he notes, interesting, the constitutional law involved in the right consideration of this measure is wholly unexplored. We enter upon it now for the first time in the history of the government. Only in the 1870s we start to think about Section 1, and Section 1 has a rival. That rival is not the 13th Amendment. Why? Because the Klan Act is designed to protect white Republicans, as well as African Americans, and for better or worse, protecting white Republicans from violence wasn't thought to be a 13th Amendment problem, but a great many representatives thought it was a guarantee clause problem. And they said, actually, the guarantee clause, the guarantee of a Republican government, if your government cannot protect you, you're not having a Republican government. Protection and allegiance are reciprocal, and the federal government can step in. And there's an interesting difference between the 14th Amendment advocates and the Republican government advocates. The 14th Amendment advocates insist, for federalism reason, on an intent requirement, which is going to prove very troublesome in trials, namely when a private figure attacks an African American or white Republican, you must prove their motive was to interfere with state laws protecting African Americans, white Republicans. Advocates of the Republican Guarantee Clause said, no, we don't need the intent requirement. If a government cannot protect its citizens from private violence, who cares? Whether they even know about the laws, we ought to be able to punish it. They lose out. By the end of the debate, it's entirely a debate over the 14th Amendment, and the intent provision is in. We see the same history in a variable story with the Civil Rights Act of 1875. It is introduced, as we all know, by Charles Sumner. And Sumner introduces this as a 13th Amendment bill. He goes on at length about the 13th Amendment foundations. To the extent there's a second foundation, it is Sumner's second favorite clause, or actually his favorite clause of the Constitution, the guarantee of Republican government. And there are a couple of speeches where Sumner, trying to ruin my thesis, history is a conspiracy against me, Sumner says, oh, by the way, there is Section 1 of the 14th Amendment, and that matters too. But that's it. Whereas we get an elaboration of the 13th Amendment, there is no elaboration of the 14th Amendment. So just to listen to a little bit, segregation. Every such attempt is an indignity to the colored race, instinct with the spirit of slavery, and this decides its character. The prejudice of color was the very basis of slavery. Therefore, in abolishing slavery, we must complete its work, abolish all the offshoots of slavery, all that grows out of slavery. When he introduces the Civil Rights Act, he says slavery in its original pretension reappears in the present debate. So what do we see in Sumner's bill? We don't worry much about state action. There are some limits, but they seem to be privacy limits. Essentially anything that has any connection of government at all. You're protected by government, you are regulated by government. If government can regulate it, Sumner says it can ban segregation. Take our great institutions of learning. Harvard College. They are not sustained by monies derived by general taxation, but they are authorized by law. Churches are incorporated. Most important, his 13th Amendment, to the extent we wanted to put it in the Constitution, belongs in Article 1, Section 8. It's a power. And this goes very much to what Professor Brandwein was saying. Congress, 13th Amendment, it is authorized to do what is necessary to eradicate slavery, the slave system, and the slave power. The power plainly exists in the Constitution. It is to abolish slavery, and it is for Congress to select the means, whatever will fortify constitutional commitments to abolishing slavery, recognizing citizenship, and enforcing equality is within the power of Congress by express grant. Well, as Sumner dies, the 14th Amendment Section 1 crowd take over. They focus on state action, not in some sense the scope of government regulation. They narrow the bill. They focus on Section 1 as granting a right that Congress should enforce rather than a goal that is achieved by legislation. More and more of them take the position Justice Bradley took, namely it's the court's job, it's my job, Justice Bradley said, to enforce the 14th Amendment. In short, rather than the 14th Amendment Section 1 being an additional protection to persons of color, the history of the Civil Rights Act of 1875 suggests the 14th Amendment was used to tame the more radical implications of the 13th Amendment. Well, what do we learn? One of the things I think we learn, and this is true if you study any of the debates, is this is a time of rapid transition. The 13th Amendment, when debated, doesn't look entirely like the 13th Amendment when debated in the Civil Rights Act of 1866. The 13th and 14th Amendments in 1871 don't look like the 13th and 14th Amendments in 1866. The 13th and 14th Amendments in 1875 don't look like the 13th and 14th Amendments of 1871. History is a motion picture, not a snapshot. We are dealing in times of rapid intellectual change, a lot of which you captured. We shouldn't think because people thought this at this time, they thought the same thing 3 months later. That's an inference not supposed. The other thing we're seeing is, in many ways, to dovetail with Professor Brandwein's story, the legalization of the post-Civil War amendments. From amendments that almost everybody thought in 1866, and Charles Sumner continued to think, empowered Congress to achieve certain goals, to amendments we know today that empower the judiciary to protect fundamental rights even against certain kinds of public policy. Thank you very much. And I hope I'm within my 35 minutes.
Once again, I'd like to open the floor for questions to Professor Graeber. Once again, if students would like to exercise some priority this way, I want to encourage that. So I will put the microphone, our traveling microphone, into the hands of Jonathan. And please indicate your interest in asking a question by raising your hand. Because if you don't, I may take.
I think Keith has.
And Keith, you have a question. I will defer.
Mark, you start off with the Miller opinion, the 14th Amendment, and the way it seemed to entrench the significance of Section 1 and downplay the significance of the other sections in our historical memory. But it wasn't entirely clear to me how much you think that's a function of what Miller was doing per se, as opposed to the nature of the judicial opinion, the particular legal problems he was confronting, and then the outsized significance that becomes in our story about judicial review down the road. So is there an alternative version of how the Slaughterhouse opinion could have been written that would have taken more account of other provisions of the 14th Amendment? Or is just as a convenient hook for you to be able to talk about sections 2, 3, and 4?
Well, first, my wife says, what are you going to have for dinner? And I say, well, this relates to the public debt, so I'm going to talk about Section 4. So everything is a convenient hook. But I think there are two answers to your question. The first is there's an amazing amount of dicta in that section. So in the part I left out, Miller talks about the origins of the 15th Amendment. The 15th Amendment has nothing to do with the case. There are other things he talks about having nothing to do with the case in his history. So I think it's not simply a convenient hook. This is a retelling of the story. And the other thing which is really worth exploring, and I don't know how to explore it, and a deep suspicion is I'm not the person who can do it. Turns out Miller had a very good friend who regularly talked to him about the 14th Amendment. That was John Bingham. That this is John Bingham's story of the 14th Amendment. And in fact, John Bingham actually endorses Slaughterhouse. So I think it's not simply that he left out Section 2 because he was being paid by the word and everything unnecessary. This is a very long opinion. We both excerpted it, right? There was a lot that was pretty easy to go like this, an excerpt. No, he gives lots of history, lots of things that aren't particularly relevant. That this is a retelling. It is the moderate conservative Republican retelling of the events of 1866. And it's worth just saying how much gets left out and its significance.
Mark, I want to give you a chance to to say more, because I know you have a very rich account of what motivated the drafting of the 14th Amendment. It's part of what this, I guess, 3 or even longer book series that you're doing to kind of present that full history. You teased us a little bit here by saying there wasn't an interest in Section 1. All the action, the focus of the drafters were on the other sections. And I think I've read you before, and I think you've spoken before about how Section 1 was Bingham's idea, and that it was something Bingham was pushing, whereas the main thrust of the other Republicans, whether it's the Joint Committee or others, were sort of with Section 2 and things along those lines. Could you? I love engaging you about that issue. I have my own opinions about Bingham, but when you say it was all Bingham's idea, what do you mean?
Okay, what I mean is there's not much evidence that, particularly after the Civil Rights Act, other Republicans really felt you needed what Bingham put in. What we do see, and this is, I think, both of us agree on, there is the great whoops moment in American constitutionalism, namely, at some point, the geniuses who wrote the 13th Amendment, and it doesn't appear to have come up in the 13th Amendment debate, said, you know what we just did? We just gave the South the means of controlling the national government, because now former slaves will count as full persons. They won't be allowed to vote. So what used to be a vote of white Southerners was worth, twice the vote of a white Northerner. Now it's 3 times. They will control the national government. That is what is pushing the 14th Amendment. In one way, as Professor Lash has noted, I'm writing interminable books on the subject. I have 2 new grandchildren who I want to go to college. Please buy the books to support their college support fund. But if we look at a comparison, the standalone version of Section 1 is debated for very short parts of 3 days. Outside of a couple of minor interventions by Thaddeus Stevens, none of the big guns get involved. They spend a month debating the standalone version of Section 2. All of the big guns are there giving very long speeches. When Section 1 amendment is tabled, they move on. When the Section 2 amendment is defeated in the Senate, there are immediately 3 other proposals made the next day. They weren't going home without doing a Section 2 thing. I can tell a slightly less story about Section 3, which is second in importance, but every objective indicator I could find, the ranking is 2, 3, 4. Oh yeah, it's 1.
Thank you.
They all agree. They don't know better. Get them before they read the case.
On Section 1, I think the argument that it does matter shows up the most in the enforcement debates over the enforcement acts of 1870 and 1871, because if you look at it's not they use this as memory from 20 years ago, but they do invoke the guarantee clause, but you have folks like James Garfield emphasizing that this was about the equal benefit of the law, and they explicitly invoke the equal protection clause over and over and over again. And they're the ones who develop this really state neglect idea in the Congress that if you don't have, if you're not having crimes against you, remedied on the basis of either your politics or your race, that is a denial of equal protection. And they're aware that they're like stretching the definition of equal protection sort of as far as it goes, and Les Benedict made this point a number of years ago. So they're, what's unexplored is, can you interpret the equal benefit of the law to cover a federal remedy when the states are not doing their job? And my memory is that they relied heavily on the Equal Protection Clause. And so I 100% agree that the meaning of equal protection morphs. It develops as this problem of clan violence becomes just insurmountable. But I think Section 1 it doesn't go away, and it really comes back in the context of punishing clan violence. And so what I was just interested in your thoughts on that.
The first thing is we largely agree. That is, the enforcement acts, particularly in the Klan Act of 1871, is the introduction and the move to prominence of Section 1 of the 14th Amendment. It doesn't show up playing a prominent role in earlier debates. Now, notice Section 1, part of the argument here, made briefly, is Section 1 does battle with the guarantee clause. Because notice, as you said, you have to do some gymnastics to get Section 1 to cover private clan violence. Yeah, that's unpunished. Yeah, oh yeah.
State
Yeah.
action is the failure.
Yeah,
You're actually not
yeah. Oh, I'm agreeing. You have to go, that's in some sense state failure there. But notice that on the guarantee of Republican clause, you don't really need those gymnastics. The state can't do it. If the state can't prevent private violence, you don't have a Republican government. Part of what I want to suggest is going on is the reason why more moderate and conservative Republicans learn to love Section 1 is because it doesn't have all of the radical implications that Sumner and Republicans want in the guarantee clause. That Section 1 turns out not to be, yes, the radical re-envisioning of American government, but the taming of the radical enterprises of other constitutional provisions. So I agree with you wholeheartedly. I just want to point out there was another way of doing it. And that they went down one path and not another is interesting. And by the way, do I have a full handle on this? No.
I'll put a question here, which is a half question. And that is, whenever I have 3 law professors in a room together with me, I immediately start talking as a history person about politics. Sometimes the temptation is to think about discussions about Section 1 or the entirety of the 14th Amendment as though it was a debate in a room somewhere in Philadelphia in 1787. And it's not. The 14th Amendment is, I love the word whoops, because it strikes me that so much of the Reconstruction amendments is an act of improvisation. It's, here's a problem, here's our fix. Oh, whoops, we didn't anticipate these responses. All right, we're going to fix it. It's like updates on Microsoft. And what you see in the 14th Amendment is a way of addressing a whoops problem. In this case, it's a whoops problem which is political and which is driven by fear. It's not so much a discussion between Republicans. It's a response of fear to Democrats. Because, first of all, drawing on what you said about the 13th Amendment, yes, the door has now been opened, not only for the return of Southern Democrats, but a renaissance of Southern Democrats in larger numbers who will come north and make, once again, as they had before, common cause with Northern Democrats, who have, in 1866 and 1867, already made it clear that they want no part or lot with Republican Reconstruction. There is an anxiety that the majorities Republicans have enjoyed since 1860 in Congress are going to disappear and disappear soon. And they are right, because those majorities do disappear. So fear and improvisation. Talk to us about the role of the politics of fear in the creation of the 14th Amendment.
I'm feeling really here upset because you've just in 2 minutes summarized punish, treason, reward, loyalty, and now no one's going to buy the book. Couple of points which are absolutely. One is improvisation, just to give another important example, which I think you know well, and that is the Joint Committee had a 14th Amendment they were going to give. At the last minute, for lots of reasons, they realized this one won't fly. We've got the weekend, but we've got to put a 14th by Monday. In some sense, Monday was the due date of the assignment, and you suddenly realize that on Friday night that your original version doesn't work. They had to put it together over a weekend. And so there's lots of things there that probably the best explanation is, that was rushed. But I think you're absolutely, this is what is motivating. This is what they're saying. Thaddeus Stevens, in his first speech on Reconstruction, says the goal of Reconstruction is to preserve the power of the Republican Party. Now, it's important, people, when I say this, people say, in other words, it's just partisan hackery. No, good, yeah, we're on the same page here. It's interesting given our politics, I think, are somewhat different. But no, the Republican Party is the party, not of people who want office holders, though they're there. It is the party of the people committed to union. It is the party of the people committed to the abolition of slavery. It is the party that fought the Civil War. It is the party of the loyal people of the North. If you want to achieve the goals of the Civil War, there's only one party that can do it. Now, it's important to understand that among other commitments of the Republican Party is republicanism. No Republican ever says the way you can achieve the goals of the Republican Party is we become a dictatorship. But they do say, as a Republican Party, we're committed to forms of Republican government, and if there are forms of Republican government that are better for small r Republicans and better for big R Republicans, we ought to move to them. So that's the argument, and that's basically the argument of the book. One way of looking at it is one of the things that's been overlooked by history. Historians have tended to discuss the 14th Amendment only when the caption in the Congressional Globe says, like, Constitutional Amendment. Turns out Saturday was open mic, or the equivalent, at the Supreme Court, and lots of congressmen gave speeches on Reconstruction, and lots of them proposed, here's what we need to do. What you see in all of them is some version of Section 2, some version of Section 3. You don't see as many of them saying some version of Section 1, and when they do, they often say, we don't need a constitutional amendment, we just need legislation. So it's 2 and 3 that are at the heart of their concern, in part, and this is, to me, the take-home point. It's not, did Thomas get the 14th Amendment right? Did Ginsburg get the 14th Amendment right? It is their belief that if they got Section 2 and 3 right, wouldn't matter what Section 1 said, the fruits of the Union victory would be preserved. They got Sections 2 and 3 wrong, wouldn't matter what Section 1 said. Fruits of the Union victory would not be preserved. If you build a big enough political base, you will get the constitutional vision you believe right. You don't win enough elections, you won't get it.
Great point. So let us thank Professor Mark Raven.
Well, thank all of you.
So We are ready now to begin, and Kurt, the floor is yours.
Thank you. Thank you, Alan. What an honor to be here. My thanks to Alan Gelso and Keith Whittington and the James Madison program. It's great to see my friends, Mark and Pam. And just what a wonderful anniversary to be here and discuss one of the most maligned cases in constitutional history. I don't know how much you know about the role of Slaughterhouse in legal education and at law schools. You wonder what kind of background people have in the contemporary argument and why you would want to have this kind of discussion. Historical case has to slaughterhouses. Thank you, Alan, for setting up the beginning. But it plays an enormous role in contemporary constitutional theory and in debates over where the current Supreme Court ought to go. I was just telling some of the students. Professor Randy Barnett has a particular view about Slaughterhouse and wishes that it were overturned, and others are attentive to a case that may be going before the Supreme Court where they might actually overrule Slaughterhouse. And what is at stake is enormous in terms of American jurisprudence. Right now, you have a situation where 14th Amendment rights, and you probably know this, 14th Amendment rights are substantially protected by way of the Due Process Clause in the 14th Amendment. Nor shall any state deprive any person of life, liberty, or property without due process of law. Even though it sounds in terms of procedure, the court has developed it so it protects the substance. Substantive due process, the court has ruled, includes protections listed in the Bill of Rights that originally only bound the federal government, but now they bind the states. At different times, the court has also construed that term to include unenumerated rights, parental rights, the right to privacy. All of the abortion cases and personal autonomy cases, those are all under substantive due process. And most scholars, and this is where I was going to begin, most scholars believe two things. One, they believe that substantive due process is a crock. I think everyone really actually probably believes that. Certainly, I think all of the justices on the Supreme Court realize that substantive due process is not a plausible reading of the original understanding of the text, and even theoretically, it's problematic for all kinds of reasons. And so there have been hints that the court might be interested in revisiting early cases having to do with that other clause in the 14th Amendment, one that scholars for years have suggested might be the better place to go for protecting individual rights. No state shall make or enforce any law abridging the privileges or immunities of citizens of the United States. But no one has known exactly what to do with the clause, right? And I think that's one of the reasons why the court has been hesitant. But the court continues to think about it, continues to read about it, and will, I'm certain, pay attention to conferences like this one in discussing the potential meaning of privileges or immunities and whether or not it's available for them to make that jurisprudential move. The first case, of course, and again, I'm going to summarize this because I'm already going to go over time. I'll try not to. The first case to seriously engage privileges or immunities was Slaughterhouse. And what Justice Miller and the majority did in that opinion in denying the claim of the plaintiffs has been characterized as one of the most implausible, stupid, foolish opinions ever written by the Supreme Court, and that, of course, it should be overruled. My federal courts teacher, Akil Amar, has famously declared in the past, virtually no serious modern scholar, right, left, or center, thinks that Justice Miller provided a plausible reading of the 14th Amendment. That was Akil Amar back in 2001. I don't know if the situation or Akil has changed since then. I know there are a few more of us who actually are beginning to defend Justice Miller's opinion, but what I don't know is whether Akil thinks any of us are serious. So, but we're there. We are there, and some of the defenders of the opinion, I think that Pam was kind of talking in this direction, and Mark may have this view as well. Some of the quasi-defenders of Slaughterhouse are actually critics in disguise. They argue that Justice Miller was wrong to reject the idea of an unenumerated right to pursue a trade, but that nevertheless, in this particular circumstance, Louisiana may have had valid and even compelling health reasons to create this kind of monopoly. So these defenders support the case's outcome, but not its reasoning. I'm not a faint-hearted defender of Slaughterhouse. I think Miller's opinion was correct, and correct not just in terms of its outcome, but also its reasoning. And the reasoning was fully consistent with the original meaning of the Privileges or Immunities Clause. And although Miller, in his opinion, does not give us the full meaning of the clause, I think what he did discuss was discussed correctly, and that the Supreme Court should not overrule Slaughterhouse. Instead, I think the Supreme Court should embrace the opinion as a correct, if incomplete, interpretation of the rights of national citizenship. So I want to present a condensed version of my defense here and why I think this is the case. But in doing so, I have to begin by clarifying what exactly Miller did when he and the majority issued their ruling in that case. In law school, way back in the day when I first studied Slaughterhouse, I was taught that Justice Miller gutted the Privileges or Immunities Clause. He rendered it, quote, a practical nullity. His opinion rejected the incorporation of the Bill of Rights. He reduced the clause to what Justice Field called a vain and idle enactment, and that by doing so, Miller had, quote, strangled the Privileges or Immunities Clause in its crib, end quote. I believed all of that. I accepted it uncritically when I was in law school, and for many years afterwards. I now know that it's just not true. And I think that anyone who has studied the case knows that these characterizations are not true. Miller's majority opinion did not reject the incorporation of the Bill of Rights. They couldn't have done so because that issue was not before the court. It was the 1876 case of United States against Cruikshank that officially rejected 14th Amendment incorporation. And when that court did so, it cited Barron v. Baltimore. It did not cite the Slaughterhouse case. The Cruikshank majority didn't think that Slaughterhouse had anything to do with the issue of incorporation. So for those of us, like myself, who support the incorporation of the Bill of Rights against the states by way of the Privileges or Immunities Clause, we believe that it is Cruikshank that should be overruled. I agree with Justice Thomas on this issue, and I hope the court will eventually follow his lead and repudiate that decision as one of the worst opinions ever handed down by the Supreme Court. But in overruling Cruikshank and embracing an incorporationist reading of the Privileges or Immunities Clause, it's not going to require overruling Slaughterhouse. Slaughterhouse should remain. It should remain as an adequate, if incomplete, explanation as to what the clause does, and that it actually can be a helpful guide to understanding what the framers and the ratifiers did when they adopted the 14th Amendment. So I want to spend a little bit of time talking about Miller's particular opinion and how he structured that opinion, and why I think it tracks quite nicely with the understandings of the man who drafted the clause, John Bingham. And Mark, thank you so much for just supporting everything that I'm going to say here. Miller adopted Bingham's view. Yes, the view of the man who drafted the clause. Okay, so in Slaughterhouse, here's what's going on. Here's some of the doctrinal moves that are happening in the case. The plaintiffs argued that 14th Amendment privileges and immunities were the same rights that were protected by Article 4's Privileges and Immunities Clause. And back in the 1820s, in a circuit court opinion, Justice Bushrod Washington, George Washington's nephew, while writing on circuit, decided a case called Corfield against Coryell. It was about digging clams out of riverbanks. And in that opinion, Justice Washington addressed a claim having to do with Article 4's privileges and immunities. And what Justice Washington said was, although the citizens in the several states are protected in getting equal privileges and immunities, the privileges and immunities they get are a limited set of local rights, only those that are fundamental and supremely important to interstate comity. And so his understanding of privileges and immunities was that if a state gives its local citizens certain fundamental rights, then they also have to give visiting citizens those same rights when they come and visit. But it's not an absolute right. A state is still free to deny their own citizens the right to make shoes or something along those lines. It's only if state law gives that right that then it has to be given equally to a visitor. And in his opinion, he said one of those fundamental rights was the right to pursue a trade. Didn't develop the idea, but basically the idea was if they let local people build shoes, then visitors should be able to build shoes too. And the plaintiffs in Slaughterhouse looked back to Corfield and they said, well, those are privileges or immunities that used to only get equal protection. Now we have those same words in the 14th Amendment. So it must be the same set of rights that are being protected. And so the right to pursue a trade, which once only got equal protection, now gets absolute protection. It no longer is dependent upon state law. We get it whether the state gives us the right or not, or whether they try to give a monopoly to somebody else or not. So the whole argument of the plaintiffs in the Slaughterhouse case required this taking rights that were in Article 4, that were once secured on the basis of state citizenship, and transforming them into absolute rights of national citizenship. That was their basic argument as far as the privileges or immunities was concerned. Miller said, no, you're wrong. And in saying they were wrong, he structured his opinion with three basic moves as to why they were wrong. First, Miller argues 14th Amendment privileges of citizens of the United States are not the same as privileges under Article 4 that involve those of citizens in the several states. Second, since adopting the plaintiff's argument would radically transform the federalist nature of the Constitution, such an interpretation should be rejected in the absence of compelling historical or textual mandate. And third, in order to counter the dissent's claim that its decision rendered the Privileges or Immunities Clause a nullity, Miller presented a non-exclusive list of national privileges or immunities, which he described as owing their existence to the federal government, its national character, its constitution, or its laws. So those are the three moves of Miller's case. And I think every one of them is plausible. So I'll just try to briefly address each in turn. First, the first move by Miller is that he distinguishes the privileges and immunities of citizens of the states from privileges or immunities of citizens of the United States. I think that is fully vindicated by the text of the 14th Amendment itself, and Miller points this out. The opening sentence of the 14th declares, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The opening sentence distinguishes two categories of American citizenship, national and state. Those categories pre-existed the Civil War. Again, they were described in the case of the rights of state citizenship had already previously been established under Corfield against Coryell. So according to Justice Washington, listen, you're trying to say that these rights of citizenship are the same, and we've already been told by the text of the 14th Amendment that we have different categories, and the text of the 14th Amendment also tells us that those rights have to be different. How do we know? Well, because if you've already got all the rights of state citizenship by being a national citizen, then we only needed the National Citizenship Clause. There must be something more that you get that required the addition of a second clause, one protecting the status of state citizenship. So the only way the plaintiffs could prevail in the case would be if they managed to convince the court to collapse the categories together and equalize the same set of privileges or immunities, and the text is already telling them that can't be right. So I think the first move by Miller is just easy. He's right. It's distinct. It's two different sets of rights. That view, the distinct privileges and immunities between Article 4 and the 14th Amendment, was adopted by John Bingham himself. John Bingham in 1871 was giving a speech explaining the meaning of the Privileges or Immunities Clause of the 14th Amendment. And quote, Bingham says, "Mr. Speaker, that the scope and meaning of the limitations imposed by the first section, 14th Amendment of the Constitution, may be more fully understood, permit me to say that the privileges and immunities of citizens of the United States, as contradistinguished from the citizens of a state, are chiefly defined in the first 8 amendments to the Constitution of the United States. If you're interested in following up, you can go to Bingham's 1871 speech, and he'll just lay out in detail. Corfield and Article 4 are talking about these rights. 14th Amendment privileges and immunities are completely different, and they are listed, articulated primarily, chiefly, in the Bill of Rights to the Constitution. They are not found in Washington's list in Corfield against Coryell. Now, Bingham, of course, in that 1871 speech was particularly intent on showing that privileges or immunities under the 14th Amendment included those enumerated in provisions like the Bill of Rights. And there are a lot of scholars who say, well, that may be true. Okay, maybe privileges or immunities includes the Bill of Rights, but it should be read as including more, right? Why not read privileges or immunities as also including unenumerated rights, such as those which have, for time immemorial, been protected as common law rights on a state level? And here's where you'll get the work of Professor Barnett and Evan Bernick, I think, and others who take that kind of broad reading, unenumerated rights reading of the clause. But that brings us to Miller's second point. Why would it be a bad idea for that interpretation to flow? In his opinion, Miller points out that if that argument is correct, then this would mean that the 14th Amendment would establish federal control not only over enumerated rights, but over the entire domain of civil rights heretofore belonging exclusively to the states. And it would establish not just federal judicial oversight, but full congressional legislative control over all local civil rights and the innumerable subjects of local civil rights, with congressional power to, quote, nullify such as it did not approve. Miller refused to adopt such a radically anti-federalist interpretation, absent express language requiring him to do so. And here's his quote about the role of federalism in interpreting the Constitution. Quote, "When, as in the case before us, these consequences are so serious, so far-reaching and pervading, so great a departure from the structure and spirit of our institutions, when the effect is to fetter and degrade the state governments by subjecting them to the control of Congress and the exercise of powers heretofore universally conceded to them of the most ordinary and fundamental character, when in fact it radically changes the whole theory of the relations of the state and federal governments to each other, and of both these governments to the people, the court cannot possibly embrace such a reading in the absence of language which expresses such a purpose too clearly to admit of doubt," end quote. Now again, unless you've studied this with professors or gone to law school, you'll have no idea how much grief they give that paragraph. What are you doing, Justice Miller, using federalism to control and limit the interpretation of a post-Civil War constitutional amendment? That must be the most perverse thing that any justice has ever done in the history of the United States, except that Miller was absolutely right. He was completely justified in using federalism as a rule of construction. Scholars and historians for years have pointed out that mainstream Republicans at the time of Reconstruction continued to embrace Madisonian federalism. You can find, I've recently published a paper showing the use of the Federalist Papers all the way through the antebellum period with antebellum Republican theory, also into the Reconstruction debates as well. Republicans made federalism part of their platform before the Civil War. After the Civil War, you'll find Madison's 45 and the 10th Amendment all over the Reconstruction debates, not by Democrats, although Democrats would raise the 10th Amendment also, but by mainstream Republicans, including John Bingham. In fact, it was John Bingham's, and here I've got to credit Mark again, it was John Bingham's moderate understanding of the American Constitution and his understanding that the federal government had limited enumerated power that led him to believe we needed an additional amendment. Federalism prompted his proposal of new constitutional text because he simply didn't share the broad nationalist understanding of power that you get with Thaddeus Stevens Charles Sumner, and others. You'll find this understanding of federalism in Michael's book, in Les Benedict's Compromise of Principle. It's all over. Eric Foner's book on Reconstruction, the Unfinished Revolution. Historians know this. It's just something that law professors sometimes forget. Federalism to the Republicans had been betrayed by the South. The South had betrayed federalism first by trying to force slavery national and denying the independent federalism rights of northern states to oppose slavery. And when that nationalist account of the Constitution failed, they then went precisely the other direction and unilaterally seceded from the Union through a radical states' rights theory. Both were violations of the balance of federal and state power that you find in Madisonian federalism. So yes, Republicans believed that they were the ones who were true to the Constitution. It was the South that had betrayed it. Whatever they produce was not going to eradicate federalism. Okay, well then what did they produce? Perhaps they would. I think that Miller was on solid ground to say that federalism, continuing embracing of federalism, would not have led those Republicans to produce an amendment that eradicated local control over unenumerated civil rights, but that leaves us with the final point of Miller's opinion. What then did it do? According to the dissenters, your refusal to embrace these unenumerated common law rights, your use of federalism to limit the scope of the Privileges or Immunities Clause, and your claim that somehow it denied this very important right to pursue a trade meant that you've reduced it to a vain and idle enactment. And Miller responds to that claim through another infamous paragraph, one that is pure dicta, but which lists, according to Justice Miller, possible privileges or immunities protected by that clause in the 14th Amendment. So let me quote what he says. We venture to suggest some which owe their existence to the federal government, its national character, its constitution, or its laws. And then he gives this long list of seemingly unrelated subjects having to do to the right to protection on the high seas, the ability to use navigable waterways throughout the United States, and to have access to the sub-treasuries of the national government, and just a hodgepodge of lists that seems made up for the occasion, and clearly involving parts of the Constitution that were already in play and already under the Supremacy Clause before the adoption of the 14th Amendment. Another reason why scholars believe that this is all hooey, that he was basically saying the 14th Amendment didn't do anything if it only involved provisions which were already written in the prior Constitution. And that is just, how can I put this? It simply misses the fact that the 14th Amendment Privileges or Immunities Clause did not exist by itself. It was embedded in a constitutional amendment that ended with a grant of congressional power. Once you understand that, now you understand why, even if Miller is right, I think he was right, the Privileges or Immunities Clause and the 14th Amendment as a whole had an extraordinary impact on American freedom. So you have, I just want to talk about his list just a little bit, because this is something that I think that scholars have completely missed. Have you studied McCulloch against Maryland? Maybe some people in political science or history courses, it's the court upheld the second bank of the United States and struck down a Maryland tax on that bank. Maybe you've also studied Gibbons v. Ogden. And Gibbons, it was a steamboat, a New York steamboat monopoly, and there was a gentleman with a coasting license, a federal coasting license, that wanted to come into New York harbors, and New York said, no, we've given Livingston and Fulton and their lessee the steamboat monopoly. The court said, no, the federal coasting license must prevail. The list that Miller presents in this opening part of privileges or immunities is a list that he had developed in a previous case called Crandall, where he discussed how the federal government could create rights with which states cannot interfere. So this list, it's just total McCulloch against Maryland kind of stuff. Access to sub-treasuries Does that sound like a bank of the United States? The protection on the high seas, the right of the federal government to give you a coasting license with which states shall not interfere. It also would include the right of Black Americans to get a coasting license, something which had been denied to them by the southern states. So this opening provision had to do with privileges and immunities that were secured by exercises of enumerated federal power. And if you go back and you look at the list, you'll see it all has to do with rights that the federal government are giving their own citizens. Those are privileges or immunities of citizens of the United States. They have to be by definition. Now that's not very exciting, because they were already there. They were already secured by the Supremacy Clause, but that doesn't make it any less true. He has accurately described one set of privileges and immunities. But then he goes further, and he also says there are also the rights secured by the First Amendment, of the right to assemble and to petition government for redress of grievances. That's a listed constitutional right that he's now described as a privilege or immunity of citizens of the United States. Now, did he think it had been incorporated against the states or still was only applicable against the federal government? We don't know. But he hasn't closed the door on incorporation by saying this. He's opened the door to more understanding. Well, what does it mean for that to be a privilege or immunity? Does it extend against the states? And then, in a paragraph that has just been scandalously undiscovered or studied by historians and scholars, listen to this. One of these privileges is conferred by the very article under consideration, 14th Amendment. It is that a citizen of the United States can, of his own volition, become a citizen of any state of the Union by a bona fide residence therein with the same rights as other citizens of that state. You may not know it, but that is explosive. That sentence and its subject is the subject in two remarkable books that have just come out in the last 10 years by Martha Jones and also by Kate Mazer, having to do with the struggle of Black Americans to get equal state citizenship in the years leading up to the Civil War. But their efforts were often thwarted, both in the North and the South. And of course, the South had passed the Black Codes, which was denying the rights of equal local citizenship to Black Americans. Miller has just told you we have a brand new right in the Constitution that defines local citizenship and gives you the same rights as other citizens. We also know from the earlier part in the opinion that he knows that it's going to come with congressional power. It means under Section 5, Congress now can pass legislation demanding equal civil rights regardless of race. This is something which simply had not existed before. And it's something that was just way up on the list of what Republicans wanted to accomplish. If you go further than that and say also privileges or immunities include the Bill of Rights, now we're getting more and more radical. Now we have Congress with the ability to enforce the Bill of Rights against state interference. You could take a McCulloch against Maryland approach to that, or a Gibbons v. Ogden approach to that, and come up with a radical protection of American freedom. And then even, another right that's listed in the Constitution, in the prior Constitution, Article 4's Privileges or Immunities Clause. Mark talked to you about the inability of white Americans, white or Black Americans, to travel from the North to the South under the antebellum period. You would have Black Americans, of course, were denied the right to travel, but even investigative senators from Massachusetts who wanted to travel with their daughter down to South Carolina to investigate the denial of equal rights to Black American sailors in South American ports were hounded out of the state out of threat of being tarred and feathered. This is Senator Hoare and his daughter. That specific episode became emblematic in all of the abolitionist literature in the North and pro-Republican literature in the North as an example of how the South was denying constitutional freedom. But the problem was Congress couldn't do anything about it because it had no power. So even if you just read the Privileges or Immunities Clause as only involving rights and powers listed in the original Constitution, but you understand that it includes Section 5, you now have Congress finally able to protect the right to travel and the right of Americans to travel from state to state, and that was a key goal of Republicans during the drafting period and also prior to the Civil War. So this idea by Justice Field that just limiting it to provisions in the Constitution renders it a vain and idle enactment simply doesn't bear out once you understand that all these rights came with powers and that protecting these specific rights and giving Congress power to protect these rights was one of the major goals of mainstream Republicans. Let me just end, and then we can just have a general conversation amongst all of the wonderful scholarship that we've heard here today. The title of my talk is John Bingham and Justice Miller's Opinion. And I've already pointed out that Bingham shared the distinction between local rights and national rights. Bingham shared the commitment to federalism that was emblematic and used by Justice Miller, again, as Mark pointed out. And Bingham also believed that the Privileges or Immunities Clause did, in fact, incorporate the first 8 amendments against the states. Now, Miller's opinion did not address that particular issue. It wasn't before the court. It is the thing left unsaid by Miller's opinion. The door then closes with Cruikshank. Cruikshank, a few years later, affirmatively rejects it. But Miller did not, which means we've got a track record here of correct throughout, correct to reject readings that would radically transform federalism, and an unanswered question. So what I would say is that the court can answer that question by saying privileges or immunities are, in fact, initially listed in the Bill of Rights, now enforceable against the states. That wasn't answered in Slaughterhouse. We are answering it now. But the rest of Slaughterhouse remains. It doesn't need to be overruled. And in fact, its insight into the constitutional theory of mainstream Republicans in the Reconstruction Congress is absolutely correct. So enough. Now we can just talk.
The floor is now open for your questions.
Where's this water? There was water, right?
May I sit so I can read from the Congressional Globe?
Please.
I want to take you back to May 23rd, 1866,
Got it.
which in the Senate, which may be the most important debate for understanding the evolution of the various sections. And this is going to get to the question of the rights of United States citizenship versus the rights of state citizenship.
Let's listen to Jacob Howard here.
Yes. They begin by reading the resolution carrying what was then the 14th Amendment, and it begins with something very familiar. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Sounds like the final form. But Howard says, well, we don't know what citizens of the United States means. And so this is on 2765, on 2768, Wade proposes, no state shall make or enforce any law which shall abridge the privileges or immunities of persons born in the United States or naturalized by the laws thereof. Which becomes the citizenship clause the next day, more or less, the next day, because May 23rd is also the day that Section 2 gets reintroduced in the floor, which is stated in terms of citizens of the United States. And they realize they need a standalone statement for who are the citizens of the United States. My question is, if Wade's initial proposal had stood, would that have had an impact on Slaughterhouse? If it was if the Privileges or Immunities Clause was simply stated in terms of persons born in the United States or naturalized by the laws thereof. and not stated in terms of citizenship, citizens of the United States.
I don't think that would have been enough. And by the way, boy, do I want to talk about the story that is happening right at that moment on May 23rd. But let me just briefly why I think it wouldn't have been enough. There were different arguments at the time in favor of applying the Bill of Rights against the states simply as a matter of the original Constitution. There were people, although the Supreme Court in Barron v. Baltimore had ruled that the Bill of Rights did not apply against the states, there were people who hadn't read the opinion, first of all, and others who simply had come to believe that the Bill of Rights should bind every government, both federal and state. But Bingham realized that was a myth. It simply wasn't true, and that in fact the lesson of Barron v. Baltimore, if you read that opinion, is that the court was not going to apply the Bill of Rights against the states unless it got magic words. It wanted to see the words that the Constitution used in Article 1, Section 10, where every limitation upon the state begins with the sentence, "No state shall." That's bills of attainder, ex post facto laws, things along those lines. So Bingham, in Bingham's explanation later on, he said we were going to be in a situation where even if we thought we had put language in there that might have extended rights, we needed the no state shall language. And I think he's probably right. I think that rule of construction probably would have still been followed. But I don't know. I mean, I'm kind of conjecturing here. Wade's proposal there, Wade had said, we have this privileges or immunities of citizens of the United States clause there, but what is a citizen and how do you become a citizen? That becomes extremely important. There's part of the story here you really ought to, it's going to be in my book. You need to buy my book. So the Joint Committee in the early months of 1866 proposes different separate amendments, some having to do with disfranchisement of the rebels or the debt or not repaying slave owners, and Bingham tries a civil rights amendment. It all fails. Fails for all kinds of reasons, objections by conservatives, objections by radical Republicans. But the Joint Committee's whole purpose was to produce amendments, and they were sending them out, and they were losing. The only thing that was successful was a Civil Rights Act of 1866, and the second Freedmen's, the readoption of the Freedmen's Bureau Act, and they're sitting there in April, and someone from outside of Congress, a civil rights advocate, Robert Dale Owen, is friends with Thaddeus Stevens, and he says, "Hey, I have an idea. Take all those proposals and combine them into a single five-section amendment." Stevens says, "It could work. It's crazy. It could work." So he takes Owen's draft. The Joint Committee fiddles with it just a little bit. Bingham, you're right, Mark, Bingham forces them to adopt his version of Section 1, but it's a smaller version than we have. It's just privileges or immunities, due process, and equal protection. It doesn't have the citizenship clauses in it. That ultimately goes to the House, and the House passes it. It goes to the Senate. Now we're in the Senate. The Senate is saying Jacob Howard presents it, and even Jacob Howard in presenting it, and he was on the Joint Committee, even Jacob Howard says, there's some problems even with this draft. And we're not really sure what citizenship means, but there are some cases like Corfield that can help us understand what citizenship means. But it's the best we can do, and we're running out of time. We're running out of time. Well, the Senate just is not compliant like the House is. And the Senate, they start making suggestions. Wade starts making suggestions. Others start, Harris, everybody wants to make a suggestion about changing things. They don't like Section 3. Section 3 completely has to go. And we have a worry about citizenship, so let's just completely take that out. And Democrats who thought they were about to lose, they start standing up. We need to make some changes here. So Jacob Howard goes, I see what's happening. Recess, and the Republicans leave and hold a secret caucus. Everybody knew about it, secret. They held a secret caucus away from the floor of the Senate. And in that secret caucus, of which no one has any report, this is Indiana Jones style, you need to find this stuff, okay? They discuss, and they give it to a subcommittee of senators who had worked on the Joint Committee. In that caucus, they produce a brand new Section 3, and they add the citizenship clauses. And that's when you get a clause that begins with the same language as the 1866 Civil Rights Act, defining national citizenship, but also a brand new clause that has never appeared before, an additional clause defining state citizenship. You are absolutely right. There was something important about adding that additional clause. They bring it back. Now the Senate says, yes, okay, we like what you've drafted. But it's that generally unknown history of the citizenship clauses that I think is extremely important. They were willing to put a stop to the process, recognizing that they needed to constitutionalize not just the definition of national citizenship. All persons born or naturalized, regardless of race, are citizens of the United States. Sorry, Dred Scott, you're wrong. You're simply wrong. But more than that, we also need to do something about state citizenship. It makes it far more important, I think, than most people realize. And Miller recognizes it. Miller makes room to talk about that sentence, not the sentence having to do with national citizenship. He takes time out to talk about the state citizenship clause as if it has done something important. I think it did something very important. I think Harlan, when sometimes we read Harlan's dissent in the civil rights cases and Plessy v. Ferguson, he's pointing to the importance of the citizenship clauses. I think he was right to do so. I think Miller's alert in that very early case should have been picked up much sooner, and I think ultimately could have been the basis for Brown v. Board. But anyhow, sorry, long answer, but what a moment that was. May 23rd, 1866.
Hello, I'm Lawson Wright. I'm a freshman.
Awesome.
So in Justice Thomas's recent concurrence in Dobbs, he talked about relocating a lot of substantive due process rights to the Privileges and Immunities Clause.
Right.
And I was curious, I mean, you kind of alluded to that at the start of your speech, but I was curious what your thoughts on that were, and as a jurisprudential move, whether you think it's compatible with Miller's opinion, especially given his talk on unenumerated rights and the sort of limits of Madisonian federalism on the clause.
Great question.
Thank you.
Thank you, Lawson. I'm going to start with my guesses about psychology. Okay. My guesses in the inner recesses of Justice Miller's brain, he probably didn't want to apply the Bill of Rights against the states, and that's why he joined the court in Cruikshank a few years down the road. But psychology is unknowable and irrelevant in this particular case. The opinion that he wrote is fully compatible. We have a Supreme Court that is quite happy to simultaneously protect the Bill of Rights and constitutional federalism. There's nothing antithetical about those two terms. All it means is that you interpret the Reconstruction amendments and the 14th Amendment in a way that still maintains constitutional federalism, even while you recognize that it altered and gave some things to national control that had earlier been under state control. So you can read it as having an effect on that original balance of federalism while still maintaining federalism. So I think there would be no need for them to overrule Slaughter-House if they abandon substantive due process and they go to the Privileges or Immunities Clause. Slaughter-House would have to be reversed if they adopt the reasoning of Professor Randy Barnett and other libertarian scholars who believe that privileges or immunities should be read more broadly than just enumerated rights, but should also be read to include certain important unenumerated rights that maybe are deeply rooted in our nation's history or tradition or something along those lines. Thank you. Do we have a question? Yes, another?
Just a push.
Push.
Maybe a difference between an historical and a legal approach
Okay.
to these matters, hinted at in your last answer. I just want to tease that out a little bit more. And one way of looking at it is the line in Perez versus Sharp that says that the right to marry means anything. It means the right to marry a person of your choice. And nobody thinks in 1947 Justice Traynor was talking about same-sex marriage. But if you take the provision literally, that's what it says. Now, the relationship here is you're absolutely right that Slaughterhouse doesn't say that nope, no incorporation of the Bill of Rights. And so as lawyers, you're allowed to say, we're not overruling the case, but as an historian, given that one, he would want to list important rights. He does want to escape Field's claim that what you've listed is unimportant.
Right.
Given that 3 years later, he does join the opinion, and all other 4 justices who signed Slaughterhouse joined the opinion. Isn't it fair to say that Slaughterhouse looks to the claim that, in fact, the 14th Amendment doesn't incorporate the Bill of Rights, even if it doesn't say so? So it's a bit of a lawyer's game to say, well, we don't have to overrule Slaughterhouse. In the same way, it's a lawyer's game that we can take some things literally, even though we know the justices didn't mean that.
It would violate the original intent of Justice Miller for us to incorporate the Bill of Rights against the state. Well, yeah, that game, the game that you're talking about. Yeah, the lawyers. This is grappling with precedent and how broadly to read precedent. And I think even under the most capacious understanding of precedent, you still have to be dealing with words that were actually written in the opinion, as opposed to psychological intent. And I just don't understand a lawyer's argument that even though he didn't say so, he didn't want to, and so therefore to be faithful to the opinion that he did not write, we should avoid incorporating the Bill of Rights. You can make that, yeah, you know, of course you can make the argument, but I think that goes a step too far, and I'd be very surprised if lawyers or the government made it. But
no, I'm not here. I won't push. I'm not making the lawyer's argument. I actually want to say it as a lawyer's argument. It's an interesting feature of lawyers' arguments that we can make these moves. But as an historian, wouldn't one say that, in fact, Miller did not believe in the incorporation of the Bill of Rights, and the reason why it's not listed there is because he didn't believe in it, as an historical matter?
Sure. Well, as a historical matter, I guess where I'd go on that one is to something that you said earlier in the day. Don't think that just because someone said something at time one means that that's what they thought a few months later. Things change. And in the 3 years between the issuance of Slaughterhouse and the Cruikshank case, I would want to know what had gone on. I have no reason to think that he was still in the same place. In other words, 3 years down the road than he was in 1873. Slaughterhouse came down. But I think you're right. I think it might be relevant maybe to reading some of his more ambiguous phrases in Slaughterhouse, and I think historically that would be a fair inquiry. Yeah.
By the power vested in me by I don't know who, I am happy to say we have come to the end of our half-day symposium on the Sesquicentennial of the Slaughterhouse cases. Being a history person who lives his professional life in the midst of a politics department and political scientists, I'm often want to say that the best kind of history is history which is done by historians who are paying attention to law and politics. But the best kinds of law and politics are done by people who are paying attention to history. And I think that today's symposium has been a corking good example of how the two work together and produce some really interesting results. I think most of us are going to walk out of this room thinking, I would like to take that idea or that theme or that notion or that footnote and explore it a lot further. Well, that will be exactly the result that we want to stimulate. And I actually have a few of those ideas knocking around in my head myself right at this moment. But let me give the last word to my colleague, Professor Keith Whittington, and he will utter the dismissal of our session. So Keith, here you are.
Closing in prayer.
So I'll be very brief. It was a terrific morning of conversation, which I very much expected. It's remarkable that after 150 years, with a lot of writing and talking about the Slaughterhouse case that's occurred over time, and then in addition to all the work that's been done on the 14th Amendment, that there are still exciting and interesting and new things to be said and written about it. The speakers we had today are really at the forefront of their fields, thinking about these issues very deeply and producing new work. They've mentioned some of the things they just published recently, but there's a lot more that's coming down the pipe from all of them. So I hope you not only rush out and buy Mark's book because he needs to send the grandkids to college, but also keep an eye out for their new work as well. And I'm immensely grateful that they joined us today and were able to share these thoughts with us today. I'm also immensely grateful to Alan Gelzo because really this whole symposium was his idea to do it. He's pushed it along. It would not have occurred to me to put this together, so I'm terribly grateful for him to have brought this to us. And I'm very grateful to the James Madison Program and the Politics Department for sponsoring it. It's been a terrific event, and I'm glad y'all are all able to join us, and I'm glad you got to see a terrific event. So one more time, if we could thank the speakers for participating.